Mr. Speaker, the Conservative government established the Ukraine Family Scheme, and in total, over 200,000 Ukrainians, mostly women, children and the elderly, have found sanctuary in the UK from Putin's war. However, a family of 6 from Gaza have applied to live in Britain using this scheme, and a judge has now ruled in their favour. This is not what the scheme was designed to do. This decision is completely wrong. It cannot be allowed to stand. Is the government planning to appeal on any points of law? And if so, which ones?
Minister. Mr. Speaker, let me be clear. I do not agree with the decision. She's right. It's the wrong decision. She hasn't quite done her homework because the decision in question was taken under the last government, according to the legal framework of the last government. But, Mr. Speaker, let me be clear. It should be Parliament that makes the rules on immigration. It should be the government that makes the policy. That is the principle, and the Home Secretary is already looking at the legal loophole which we need to close in this particular case.
Last week, Sir Keir Starmer called it wrong that a Palestinian family was allowed to stay in the UK through a scheme meant for Ukrainian refugees. But now, England's most senior judge, Baroness Carr, has stepped in, calling Starmer's comments deeply troubling and warning that the government must respect judicial independence. So what exactly happened? And why is this sparking a major political and legal showdown? Let's break it down. At the centre of this storm is a Palestinian family who applied to stay in the UK under a visa scheme originally designed for Ukrainian refugees. Their request was initially rejected, but later upper tribunal judges ruled in their favour, citing Article 8 of the European Convention on Human Rights, ECHR, which protects the right to family life. But this didn't sit well with Conservative leader Kemi Badenoch, who slammed the tribunal's decision as completely wrong. And then came Keir Starmer. At Prime Minister's questions, the Labour leader openly criticised the ruling, saying it was a mistake to allow the family to stay. That's when Baroness Carr, the most senior judge in England and Wales, stepped in with a sharp rebuke. Baroness Carr didn't mince words. She said she was deeply troubled to learn of the exchanges between the PM and the leader of the opposition, warning that government figures should not undermine judicial independence. Her message was clear. Both the question and the answer were unacceptable. She reminded MPs that if they disagree with a court ruling, there's a proper way to challenge it, through the legal system, not by politicising judicial decisions. In short, stay in your lane, politicians. But not everyone agrees with Baroness Carr. Legal expert Richard Eakins KC called her intervention ill-advised, arguing that politicians have every right to challenge court rulings. He insists that neither judicial independence nor the rule of law mean that judges are beyond criticism. The government also doubled down, defending Starmer's comments, saying, "Parliament makes the laws. If something isn't working, we'll change it." And let's not forget, Starmer himself is a former chief prosecutor, so his respect for the judiciary isn't exactly in question. This case has ignited a much bigger debate. How much power should judges have? Should politicians have the right to publicly criticise legal rulings? Or does that threaten the independence of the judiciary? One thing is clear. This legal battle is far from over. What do you think?